What can we learn from a $22 million verdict against Wells Fargo for disability, discrimination, and retaliation? I have a lot to say about this. I'm Karen Michael, and you're listening to The Job Judge. Welcome to The Job Judge, the podcast for anyone who works. I'm Karen Michael, your host of The Job Judge, where together 1 week at a time, we navigate through all those legal landmines and workplace dysfunction that's probably happening in your organization. And together, we are going to make workplaces work. Now, a couple things. First, I am an attorney, but I cannot give legal advice here on the podcast. It really is just general guidance. And the other thing is, we do talk about sensitive subjects here on The Job Judge, so that's just a forewarning. And finally, you're not going to want to miss an episode of The Job Judge. If you are an HR professional, if you're a business owner, if you're a manager, if you work, you want to hit that subscribe button so you don't miss an episode of The Job Judge. So let's talk about this case. There's a law under federal law. It's called the Americans with Disabilities Act. And under that law, employers who employ 15 or more employees must provide reasonable accommodations to qualified individuals with a disability unless doing so would create an undue hardship. And as part of that law, an employee who needs an accommodation for a physical or mental impairment that significantly impacts a major life function, somebody with a medical condition that is considered a disability, must tell the employer, I need an accommodation of some sort so that I can be successful in this job. And then the employer is required to engage in what's called the interactive dialogue discussion. And it's a give and take. And the employee might not get exactly what they're looking for, but they are entitled to get what they need if it is reasonable. And that's how the system is designed to work. So there was this employee that worked at Wells Fargo, and I'm going to tell you the story, and I'm basing the story on the summary judgment decision from the judge. So this case was filed by this plaintiff, and the case went and proceeded to litigation. After it went through litigation, there's this time period where the defendant, Wells Fargo, can say, look, judge, there's really not enough facts here to go to trial. And these are the facts that we know them. And assuming everything is favorable to the plaintiff, they still can't win, drop the case. And at that stage, a judge decides whether it's going to proceed to trial. And in this case, the judge decided that the majority of the complaints could go to trial. And the judge wrote a decision. And I'm going to read largely from that decision. So here are the facts of the case. Now, one of the things that's unfortunate, I think, about the ADA and cases that arise under the ADA is that a person's personal medical information gets disclosed because these cases are published, names are published, their personal business is published, whether it's a case of somebody who's got a mental impairment, somebody who's got a physical impairment, all your medical business is kind of out there. So to protect the privacy of this plaintiff, I am going to refer to him as CJ. If you want to go look up the name and all that, you can, but I don't want to perpetuate sharing this person's personal name. So I'm just going to refer to him as CJ. So according to the case, in 1990, CJ was injured after falling from a balcony, which resulted in a fractured spine and significant nerve damage, leading to permanent paralysis of his colon and bladder. This requires CJ to use a combination of laxatives. See how kind of personal this is, and yet this is kind of the case. Quote, to counteract his colon bladder paralysis to facilitate the production of bowel movement. Though the medication often causes bloating and cramping, it effectively creates bowel movements every 2 to 3 hours. Since 1997, 7 years after this injury, plaintiff CJ was employed by Wells Fargo and its predecessors. While employed in their California offices, CJ took his first dosage of medication at home, arrived at work at 4:45 in the morning, took his second dosage of medication upon arriving to work, and because the office where CJ worked from was only about 15 employees, the two-stall bathroom located roughly 10 seconds from his work area accommodated his medical condition for nearly 12 years. So he's working there 12 years, no issue, this is not a problem, everything's going well. And then that daggone pandemic hits. During the global pandemic of 2020, CJ, then a senior sales securities manager, relocated from the Los Angeles office to Wells Fargo's Charlotte office. Though working remote during the pandemic, plaintiff was familiar with defendant's trading floor from which he would be expected to work and foresaw issues with his ability to access the bathroom. So he's working from home. He's familiar with the Charlotte office. He understands that that office might present some barriers to him being able to continue to facilitate his medical needs of being able to use the restroom. On August 31st, 2021, through an Americans with Disabilities Act advocate and law firm, plaintiff formally requested a work from home accommodation to be able to continue working remotely after those COVID restrictions were lifted. As part of the request, CJ provided a letter from his physician documenting his medical needs. And sometimes that is necessary. Sometimes if you need an accommodation, you're going to be required to provide that medical documentation. On October 21st, 2021, Wells Fargo assigned CJ an ADA accommodations consultant. This woman is the hero of the story. She gave great advice. Unfortunately, based on how I read this case, Wells Fargo ignored it. And now they have to write a check for $22 million, although it'll probably get reduced for caps and things like that. But this woman was assigned to work with plaintiff's managers to facilitate the request. She contacted CJ's manager, let's just call him John, to explain CJ's requested accommodation. John requested that his manager be included in the meeting with the ADA coordinator. The ADA coordinator met with both managers on 2 occasions to discuss questions they had regarding CJ's accommodation request, including how the accommodation would affect CJ's ability to travel for work. At the request of the managers, the ADA coordinator clarified with CJ that travel would not be affected as he is able to self-mitigate his bathroom needs while traveling. So that concern that the managers had up front, which is fine. I mean, if you have a concern, this is the time during the interactive dialogue to kind of get it all out there. But that's now been relieved. On November 3rd, 2021, Davis again met with the managers. This was the ADA coordinator. The managers determined that CJ would not be as effective and productive while working from home. You wonder, where's that coming from? Has he not been effective while working from home during the pandemic? Is there some specific reason why he has to be in the office? The ADA coordinator, because she's good at her job, suggested that CJ be allowed a 6-month work from home accommodation after the return to work order to evaluate the effectiveness of work from home as a reasonable accommodation. But those managers, they didn't listen. They didn't listen to the expert, who's the ADA coordinator, which is why she's there, is to coordinate these ADA requests. And these managers denied CJ's request, claiming it would, quote, be delaying the inevitable. So the 6-month suggestion was off the table. Despite CJ's managers denying the work from home accommodation in discussions with the ADA coordinator twice told CJ that no accommodations are off the table and further requested follow-up with CJ's doctor to understand whether there were any sufficient in-person accommodations available. She is really good at her job. This is what the ADA is all about. It's kind of going back and forth and finding a way to get to the win. What can we do that is effective? By the way, this is DEI in action, trying to make sure that employees have the tools that they need to do their jobs. Requesting an accommodation under the ADA is no big deal. We want people to be successful. Employers should be more than willing and happy to try and accommodate our talented employees so that we can keep them and make sure that they can be successful. After the ADA coordinator received additional documentation from CJ's doctor, the ADA coordinator again met with the managers. She informed them that it was recommended by herself and legal that a 3-month work from home trial period be allowed following the return to work order to assess effectiveness and mitigate risk. The managers escalated that with his line of business, and all of that was produced in this case. In a meeting with the ADA coordinator, the manager's concerns were raised over, quote, regulatory and compliance measures that could be implicated if plaintiff were allowed to work from home. Well, hasn't he been working from home all this time since the pandemic started? Now it's been, 2 years, or at least a year and a half. Ultimately, because Wells Fargo delayed the return to office order, the managers informed the ADA coordinator on December 28, 2021, that plaintiff can continue to work from home. At this point, we are delaying making a final decision on this issue until a later date. So the accommodation case was closed. So the employee was never actually received the accommodation, but the employee did get to continue to work from home. But simultaneous to CJ's accommodation request, the Wells Fargo Corporate and Investment Banking Division began discussing reduction in cost methods, including potential layoffs due to global financial conditions. In and around August of 2021, they had put together some business case for reduction in force. And the first pool of managing directors considered for displacement consisted of males over age 40, but did not include CJ. So before he asked for an accommodation request, I guess he wasn't included, is the point. After performance rankings were considered, leadership, et cetera, they looked for additional people to be displaced. And between November and December of 2021, in light of revenues continuing to decrease within the investment division, they determined an additional managing director would need to be displaced. And sure enough, it was CJ. He was included in the second pool of candidates. Now, I will say his total compensation was $2.6 million in 2020, and they determined his termination would result in the most cost savings. I will admit that when my husband read an article I wrote about this case, he said, this person really made $2.6 million. That seems like a pretty good field to go into if somebody's looking to go into a career. On December 6th, plaintiff was selected for displacement, and a revised version of the business case for reduction in force was approved in December 2021. And then he was notified in February 2022. In February 2022, Wells Fargo informed employees they would be required to return to the office on March 14th, 2022. But just a couple weeks before that, on February 24th, CJ was terminated, and he filed the lawsuit based on, he also sued for age discrimination, but that actually was dismissed on summary judgment. But he sued claiming that he was discriminated against based on his request for a reasonable accommodation, that he was denied a reasonable accommodation, and that he was retaliated against after requesting a reasonable accommodation. And this case went to a 5-day jury trial, and the jury agreed that he had been discriminated against. Now, one of my favorite things in researching cases is actually looking at the jury verdict form, because I think it's so fascinating. And I'm going to put it up here. If you're watching on YouTube, you can see how the jury, there's a typewritten question for the jury, and then they handwrite in the numbers or the answers to the question. And I'm always so fascinated where they come up with these numbers, and they're handwriting it in. And so the first question is, was he terminated because of his disability? And the jury wrote in yes. And then the next question was, was Wells Fargo liable under the Americans with Disabilities Act for failing to provide reasonable accommodation? Jury said yes. Then they asked, is Wells Fargo liable for unlawful retaliation? Jury said yes. Then they asked, is Wells Fargo liable under North Carolina state law? Because they also sued under state law for wrongful discharge. Jury said yes. So all accounts, the jury was not buying what Wells Fargo was selling as to their justifications for the decisions that they made with this employee. And so the question was, what amount of compensatory damages is he entitled to, if any? For back pay, $6 million, front pay, $14 million. Now, he was a high income earner, so that could justify the $20-some million verdict. He was also entitled, according to the jury, to $100,000 for emotional distress. And then they asked if they have to pay punitive damages, which is designed to punish the company for their misconduct. And the jury said yes, that he's entitled to $1 million in punitive damages for violations of the ADA, and for violation of the North Carolina law, he was entitled to another $1 million. What is the takeaway of this case? Well, first of all, the entire ADA is designed to be an interactive dialogue. It's not this rigid process. It's designed to be a fluid process where you have these conversations and you try to get to the win. And in this case, Wells Fargo had an expert. They had a woman whose job it was to coordinate the ADA. She's the ADA coordinator. And the managers just dug in their heels And then that basically their attitude was talk to the hand. We're not listening to you. We're going to do what we want. We're going to pull out a bunch of words like regulatory and blah, blah, blah without providing any real justification, without saying, well, I mean, he's been successful. He made $2.6 million in 2020. He must have been doing something right in 2020. So there's no evidence that he's a screw up. So it's truly just preference, and preference to have somebody on site. That's not the test. The test is an essential function of the job to be on site. And if so, how often? Sometimes you could have a job where maybe it is an essential function of the job to be on site 2 or 3 days of the week, but not all days of the week. Maybe you have to be on site for meetings. He even said he could travel. So the takeaway is whenever an employer receives a request for a reasonable accommodation, employees don't get whatever they want. Just because somebody asks to work from home doesn't mean they get it. You need to see the medical documentation. You need to evaluate what the needs are of the position. If somebody is a lifeguard, obviously that person can't work from home. That's not going to cut it. So you look at what the job is, what the job requires, and whether on-site attendance is an essential function of the job, and if so, how often. And just because you have a preference, it may be easier for you to have somebody working on-site. That doesn't mean that that is something that you can't provide an accommodation for. You probably can work together, work something out to make sure that you make that effort, have that interactive dialogue so that you can provide a reasonable accommodation. Now, there are some great resources for employers and employees I want you to know about. You can go onto eeoc.gov, and there are guidance that the experts at the EEOC put out regarding reasonable accommodations in the ADA. They're for employees, they're for employers. There's also an organization called the Job Accommodation Network. That is a free resource. If you've got diabetes, if you have PTSD, whatever the medical condition is, you can type that in and it'll provide examples and options for potential reasonable accommodations. And I think it's very helpful, and it's a free resource for people. So for HR people, managers, business owners, and employees, everybody working together. Now, remember, if you need an accommodation, you have to ask for it before there's an issue in the workplace. The ADA is prospective, not retrospective. So you can't wait before you're being terminated to say, oh, I didn't tell you I need a reasonable accommodation. If you need an accommodation, you have to ask for it before there is an issue in your workplace. Now, every week when we do this podcast, at the end, I do an Ask the Job Judge section or segment where I answer a question that someone's asked me either via email at Karen@thejobjudge.net, where you can write to me and I'll potentially answer your question here on the podcast, or you can ask me a question, make a comment on my TikTok or my Instagram, where I post a lot of additional content. So feel free to follow me on TikTok or Instagram and ask a question there. I might answer it. This one, though, comes from Reddit because I just read this question and I just thought it was a bit amusing and deserved a response. Here it is. This person writes, write-up was so unfair. This person says this: on my weekend off, I took a flight to visit some family. I had every intention on flying back the same day I had work. Unfortunately, my flight was delayed 5 times prior to being canceled for the next day. Supervisor says, quote, we'll discuss this tomorrow when you get back. When I go back to work, he provided me a counseling sheet for having to take an emergency personal day due to the flight issue. Is the write-up so unfair? And the answer is no. That is poor planning. You're flying back the day that you had to work. Have you been to an airport recently? The likelihood of you being on time on a flight these days is pretty low. Now, I will agree, maybe 10 years ago when I flew, I would think, oh, I can probably get there the day of if I have to be somewhere. But these days, that's not reliable. And your manager didn't fire you. Your manager didn't suspend you. Your manager gave you a counseling memo that basically said you took a day off that was unplanned, and this is your counseling memo. And as long as that's how they treat any employee who has an unexpected time off, basically a no-show to work, as long as everyone gets that, unless they're protected by something like FMLA or some legal right to be off, because FMLA gives you the right to sporadically take time off of work, but that wouldn't be the case here. As long as everyone gets counseled like that, you're getting counseled. And I give your manager credit for addressing this head on. Kudos to the manager. The manager did exactly what the manager should have done. The manager said, okay, we'll talk about this when you get back. And then when you got back, the manager talked to you about this. Good for the manager. Sometimes we as employees don't want any accountability for anything. We've got 1,000 excuses for everything. Sometimes there's a time to take accountability and just say, my bad. I should have had better planning. I didn't come to work as planned. I did have to take an emergency day off. And potentially it seems that the system of the organization is to issue a counseling memo. Oh, well, next time, plan better. Now, you're not going to want to miss an episode of The Job Judge, so be sure to subscribe. Hit the subscribe button so you don't miss an episode. I'm Karen Michael, and you've been listening to The Job Judge.